right, so you met with the department rep, you're going to plead to impeding, right? And that's what you want to do? To that charge of impeding traffic, responsible or not responsible? Okay, I'll accept the plea, dismiss the speed, 150, and you're all set.
Okay.
Have a good day. Merry Christmas.
Merry Christmas.
Today, 22nd. People against Austin Earl Tolbert. 5T646-834. Your name?
Awesome.
All right. So you're going to plead to impeding the traffic. You filed a motion to set aside the fault. I'm trusting that they have no objection since they sent that in. So I'll go ahead and grant the motion to set that fault judgment aside in. So I'll go ahead and grant the motion to set that fault judgment aside to the charge impeding traffic, responsible or not responsible.
Responsible.
Okay, I'm gonna accept the plea. 165 is your total. Is that bond in your name, sir?
It is, Judge.
Yeah, so we'll apply the bond and you're all set. Merry Christmas to you. Tanver Chowdhury versus Car City Complete.
Judge, the attorneys are in a breakout room still. You want me to ask them to come out?
Oh, no, if they want to talk, they can talk. I'm fine.
Okay.
Why don't you have a seat? The lawyers are in a breakout room, okay? And as soon as they come out, I'll be glad to recall the case. What else do I have? Anything else? Okay. People against Horn, Nicholas J. Horn. 25T704225. I'm gonna need Emily in here, John. And then that is part of one show cause dated December 22nd.
Good morning, Your Honor.
Your name?
Nicholas Horn.
I need to wait until the probation officer comes in on this.
You said it's gonna be a few minutes.
Okay. You have a charge of failure to submit to biweekly testing as ordered on December 15th, 25. That is the charge. You plead guilty, or if you're found guilty, you have 7 prior technical violations. Your probation could be revoked. You could be incarcerated for up to 1 year. Do you understand that? You just sign the advice to rights and read and understand the rights.
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that? You have the right to an attorney. Be happy to provide you with one at public expense if you would like one. Would you like an attorney?
No, thank you, Your Honor.
To the charge, you failed to submit the biweekly testing as ordered on December 15th of 25. How do you plead?
Guilty, Your Honor.
Failed to appear for testing on that date?
I did, Your Honor.
Anybody force you to plead guilty?
No, Your
Why weren't you there?
To be honest, I did not know that I had to drop that day. I wasn't calling regularly. With my new job, I've been working later hours. I've been working.
Slow down, slow down, slow down. I need a second page of the register there. What do you mean you didn't know you had the test?
I've been calling regularly. And with my new job that I just got, I work later hours. So
I don't know what that means.
So
I don't know what that means. What do you mean work later hours?
Yeah, later on.
What time?
Like 11, 12.
3 at the
1 o'clock in the morning sometimes.
Okay,
I wake up at 5 a.m. to call.
okay.
And just didn't register in my head that that was my color. So now I've been calling twice a day. And, you know, I've been changing my head, my morning habits, so I don't miss my colors up with me. And that's some prior technical.
Yeah, I know.
But if you look at those technicals, Your Honor, none of them are, and not inclusive testing, either weekly or bi-weekly.
Aren't you supposed to go out of town?
I'm trying to talk to you.
You're not gonna probably go out of town now. I hope you didn't buy an airplane ticket.
Think about it. Is there any way I can?
Hang on a second, slow down. You're in trouble here. I mean, you just don't test. You didn't test August 30, you didn't test August 31, you didn't test September 1. We were gracious enough to allow you to go out of town preliminarily. You missed SoberLink blows back in August.
I wasn't allowed to go anywhere, John.
I don't know what you mean. We were gracious enough to grant you permission, right? You were supposed to leave in a couple days,
Oh, yes.
Yeah.
Yes.
even though you missed all these tests. Where are you supposed to go?
Or
Who are you gonna see in Florida?
it's just a vacation for my girlfriend's birthday,
For your what?
my girlfriend's birthday. We're, the family trip.
Yeah, let's leave. I'll wait until Mr. Sino comes in there, okay? I'll accept your plea and we will have a hearing then and I'll decide what I'm gonna do. Have a seat. Don't act put out with me either. You can't miss testing. We've told you that. I probably wasn't harsh enough when you did it before. Grace Victoria Lozon, 25B150021. Name?
Grace was on.
All right, so you met with the department rep. You were going to make a tender a plea to impeding traffic, right? When the improper lane use will be dismissed, correct?
Yes, Your Honor.
And that's what you want to do?
Yes,
To that charge of impeding traffic, do you plead responsible or not responsible?
plead responsible.
I'll accept the plea, dismiss the original charge, 150. You can go down the hall and take care of that. You're all set. Good luck.
Thanks a lot.
Roger, Lee, Oren, second. 25B149952. Your name, sir? All right, so you met with the department rep. You're going to plead to impeding, right? They're going to dismiss the improper pass? Yes. To the charge of impeding traffic, responsible or not responsible? Responsible. I'm going to accept your plea, dismiss the original charge. $150 is your total. You can go down the hall and take care of that. Merry Christmas to you. Thank you. People against, Marina Rabidziewska. I don't know if I'm pronouncing that correctly or not.
She's on Zoom, Judge.
Okay, 25B149161A and B. Name, ma'am?
Marina Rabajovsky.
All right, did you come in and talk, did you make your payment November 14th?
No, I did not.
Why did you come in and talk to me like I told you to do?
I talked to my probation officer and Emily told me to do Zoom. And I did do it one day and I sat there and then it was the day that you were not even there. And yeah, now we're here.
What day was that?
It was a Monday. I can't tell you exactly the date. And she apologized. She said, I forgot that he is not there today. I'm so sorry. Whatnot. And so then
All right,
she
I
told
remember
me
I got snowed in. That was in, the day after Thanksgiving, this Monday after Thanksgiving.
possibly. So then I talked to her again. And she
All
told
right,
me
you gotta talk to me on or before the due date from now on, though, okay?
Oh, okay, absolutely. I'm sorry.
That's what I told you before, and you still didn't do it. If you didn't do it until December 1 or whatever day that was. So I'll extend, how much time do you need now?
I honestly, as much time as you can give me, because
Yeah.
I have my car. I have to pay for like my car and stuff in order to even go to drug screens and all that stuff. It's in the shop. I'm in a lot of debt with a lot of stuff has broken.
Where do you work at?
I DoorDash. So right now I'm paying for a rental daily so I can continue door dashing until I can get my car out of the shop.
All right, I'll extend your time, but you gotta come and talk to me on it before the due date if you don't have the money.
I
Okay? If
absolutely will.
you show up a month late next time, I'm not gonna do that, all right?
I
Starting
understand.
January the 23rd, you pay 50 per week, okay?
Okay, thank you so much, Judge.
Yeah, if you don't have the money, you gotta come talk to me then, all right?
Absolutely, I apologize.
All right, good luck. Merry Christmas.
Merry
Thank you.
Christmas to you. Thank you so much, Your Honor. Do I just sign off?
Yeah, you're all set. Good
Okay,
luck.
thank you so much.
You're welcome. All right, people against. Andrew James Neal, 25F245194. Mr. Neal, your name?
Andrew.
All right, so you met with the department rep, right? And you are going to plead responsible for impeding, and they're going to dismiss the stop sign, right?
Yes, sir.
To the, excuse me, to the charge impeding traffic. Responsible or not responsible?
Responsible.
All right, I'll accept the plea. Dismiss the original charge, 160, cashier end of the hall to your right. Okay, you got to take your hat off in the back there, sir. Ashton James Grzecki, 25F245154. Or 124 rather. Me?
Ashton, that's
What do you think I'm thinking right now? Who's this with? Mom, if he wants to be a NASCAR driver, have him go in the, I'm not kidding. I don't find this funny. 84 and a 35?
I just was not paying attention.
That's how people die. That's how people get hurt.
I was not paying attention whatsoever.
I'm not amused in the least. That's ridiculous. I'd rather you be going 120 on I-75 than 84 and a 35. Think about it.
Oh, I did.
I don't think you deserve impeding. And I don't quarrel with them back there. I let them do their thing, but for the most part, but wow. What were you weren't having a heart attack or anything, were you?
No.
Where were you going? That was so important that you get there.
I wouldn't say it was important to go there. I shouldn't have been going that fast at all.
Where were you going?
I was going to my brother's house.
The charge impeding traffic, responsible or not responsible?
Responsible.
Please accept it, 220. Go down the hall and pay them. Don't come back and ask me for another impeding if you're driving anywhere like that. Good luck. Nicholas J. Horn, 25T704225FY. Morning, Sergeant. Give me hands up. Your name, Mr. Horn?
That's one.
All right, Mr. Sino.
Oh, you know?
So he pled guilty. He waived his right to a lawyer. Do you still wish to waive your right to a lawyer? What in the world is going on with him? He's telling me he was working later or something. I don't know what, and I had to act like a dentist to pry it from him. And he said he worked till 10 or 11 or 11 or 12 and had to get up at 5 to call, and he didn't pay attention. Was the sent right? Am I right or wrong? Did I?
Yeah, I get home later. The restaurant will be closed until 10 o'clock. I don't be out there until 11:30 midnight.
Where's that at? What restaurant again?
Bessa?
Where's that at?
Woodward, Congress.
What do you?
And then, I wake up early to try and make the morning drops because I can't make the afternoon drops. When I was notified that I did miss the drops, I went and dropped.
When?
That day on Friday.
Did he?
You didn't go till the 18th. I'd already,
18th.
yeah,
Hang on. You're supposed to go the 15th. Why'd you wait till the 18th?
I didn't wait on purpose, Your Honor.
Why'd you wait until the 18th?
That's when I was notified that I was supposed to go drop on the patient.
Enlighten me.
He contacted me because he was granted permission to travel, assuming he was still compliant. He's supposed to leave December 26th. So when he contacted me for that, I told him that he missed the testing, so he might not be permitted to travel any longer. And then he went to test today, I told him.
Working hard and trying to get better and being compliant with everything. This really wasn't a good accident. Having calling twice a day, I used my mouth. And making sure that I'm more than awake when I call, so that way I don't misinterpret whatever the automated voice is saying on television.
What do you think here?
The travel is difficult because he wants to leave. It would be, was it January 26th to the 6th?
So December 26th to January 6th?
So I mean, I could have him test when he gets back, but it still doesn't cover the whole trip. So
Was it drugs or alcohol is his substance of choice here?
alcohol,
Well, why not have him take a sober link?
Okay.
This is now 8 total technical violation. My patience is running thin with you.
You gotta get that phone out of the building.
Why are you guys in here with?
Gotta go out of the building.
We got signs, folks, we got signs all over, please. You can't come in here with phones. If you have a phone, please. DNA is probably not open on Christmas, is it?
I would have to look on DNA on site, it should be. But only in the morning, they're open every day.
And you're gonna be gone what days?
26th, the morning of the 26th through the 4th.
Anything else you want to say?
I apologize for having to be here talking to you right now.
You served 2 days on the court work program. You're gonna pay $70 for that. You're gonna pay additional costs of 75. You owe the court 145. You can go on your trip. You're to be on the SoberLink device the entire time. And you are to test the day before you leave for Florida. And the day following your return. I don't care if it's DNA on site. I could care less. Do we understand one another? Do you have the 145? All right, we'll set you up on the court work program. And you're all set. Good luck. You talked to Ms. Tessino before. Thank you. People against Nicholas de Blasio. 25W848, I'm sorry, 25W8400518. All right. You come up to the podium and tell me your name, please.
Hello, Nicholas Blavio.
You're going to plead to impeding. They're going to dismiss the fair to signal and observe, correct?
Yes, please.
To that charge, impeding traffic responsible or not responsible.
Responsible.
All right, I'll accept the plea 150. Merry Christmas. Original charge dismissed. You can go down the hall. Good luck.
Merry Christmas. Thank you.
Thank you. Washington, Azaha Stephen Washington, 25W8402626. Good morning, sir. Your name?
Good day, Your Honor. Isaiah Washington.
All right. You're going to plead to impeding traffic, right?
Yes, sir.
All right, to that charge, responsible or not responsible?
Responsible, Your Honor.
All right, I'll accept the plea, dismiss the original charge. 150 is your total, okay?
Thank you, sir. Happy holidays.
Same to you. All right. Phillips. Barbara Gale Phillips, 25W8407228. Good morning. Your name, ma'am? All right. You are going to plead to impeding, right? Responsible or not responsible? All right, I'll accept your plea, dismiss the improper lane use, 150, you're all set. Merry Christmas to you. All right. Lauren Louise Lizenus. 25T647191. Good morning. Your name? All right, so you're going to plead to impeding, right? Responsible or not responsible to that charge? All right, I'm gonna accept the plea, dismiss the speed, 150 is your total. Merry Christmas. You can go right down the hall and pay that. Good luck. Austin Michael Benny, 25T647179.
Morning, Earl.
Good morning to you. Your name?
Austin Benny.
All right, so you're going to plead to impeding, right?
Yes.
Excuse me. To that charge of impeding, responsible or not responsible?
Responsible.
Please accept it. 155, cash your end of the hall to your right. You're all set.
Thanks,
Good
sir.
luck. Merry Christmas to you. Which one does Dean, they want to hear that? The informals, right? Kaima C. Kaima Janae C. 25 W848840892. Good morning. Your name?
Steve.
All right. You got some priors. You got to be careful. You're going to plead to impeding, right?
Yes,
To that charge, responsible or not responsible?
responsible.
All right, I'll accept your plea. 175, original charge dismissed. Be careful and slow down, please, okay?
Thank you.
Merry Christmas to you. Do you need Dan's?
It's informal, the rep might have, rest of them, they're driving.
Which one do you have?
Mr. Marks, your honor, he's here.
Is he in the courtroom?
He also has one on Zoom for Joseph Payne.
I don't have the informal, the rep's got it, so he's in there fine.
Why don't you? Maya Nicole Bailey, 25G306372B. All right, you have a 3-count violation. You're charged with failure to attend your scheduled probation visit on December 4. That's count 1. Count 2, you failed to attend the anger management program. Count 3, you failed to pay your fines and costs as ordered. If you plead guilty or if you're found guilty, your probation on these could be, let's see, that'd be 4 technical violations. Your probation could be revoked. You could be incarcerated for the maximum in this case, which is up to 90 days. Do you understand that?
Yeah.
Sign the advice of rights and read and understand the rights.
Yeah.
If you plead guilty, you will be giving up all those rights, and there's not going to be a hearing or a trial of any kind. You understand that? You have the right to an attorney. I'll be happy to give you one at public expense if you would like one. Would you like a lawyer? Are you sure?
Yeah.
As to count 1. That you failed to attend your scheduled visit on December 4th, how do you plead? You failed to attend your scheduled visit on December 4th, 25.
Yes.
Did you fail to attend?
Oh, yeah.
As to count 2 that you failed to attend the anger management program, how do you plead?
Yes.
Did you fail to do that? Did you fail to do that? Is the count 3 that you failed to pay your fines and costs as ordered, how do you plead?
Yes.
Did you fail to do that?
Yeah.
Anybody force you to plead guilty?
I pay my fines up. I have a receipt for that.
All right, I'm gonna accept your pleas to all 3 charges. You have a seat and I'll be back with you. We're gonna get Ms. Tessino in here. And maybe you can tell them to bring in these couple if they, I don't know why you would be here. Did they not already request an informal? You can have a seat. I'm gonna get the probation officer.
No, Your Honor, I actually only have one subpoena for today, and it's for a case I've not even heard you call yet. That one is 840407.
You know what that is? The name?
It is a Lamar Marks, and that's a commercial motor vehicle violation.
Lamar Marks.
And Judge,
Alright.
I'm showing the department rep for, they're probably taking care of that one. Okay, my apologies.
No problem. Okay, let's bring in the lawyers on
Judge, they are back.
Tanvir Chowdhury versus Car City Complete LLC, 25-04462. All right, gentlemen, your names, please.
Your Honor, I don't know if opposing counsel is back, is he? I guess
I'm
he
here.
is, yeah. Sorry,
Yeah.
John Ivanchik on behalf of the plaintiff who is apparently there in person.
Mr. Eunice, your appearance?
Good morning, Your Honor. Bassam Eunice, PA 5962, appearing on behalf of the defendant, Car City Complete.
Do I have an appearance from you?
We do, Your Honor.
Yeah.
It came in Friday, just didn't get reprinted on the register.
That's fine. Your name, sir?
Good
You.
morning, my name's Tanvir Chowdhury.
Did you guys resolve this?
No,
Unfortunately
I
not,
was-
Your Honor.
Yeah, I was trying to get in touch with my client after myself and Mr. Eunice were talking, and apparently he's there in person and doesn't have his cell phone on him. So kind of hamstrung to try to resolve this if I can't talk to him.
Is Mr. Chowdhury in here?
I'm right
Yeah,
here.
he's at the podium.
You don't have a cell phone?
Oh, it's in my, truck.
Do you want him to go out and get a cell phone and call you, or what do you want to do?
Yeah, if we could, Your Honor, I'd like to talk to him to see if we can try to get a resolution here after Mr. Eunice has spoken to his client.
Why don't you do that, sir?
Okay.
Go out and call your lawyer, and then you come in here, okay?
Okay.
Thanks.
Thank you.
Thank
Thanks,
you,
Your
Your
Honor.
Sorry about that.
That's all right. All right, I need to refocus here. What is Lamar Chase here for, Sergeant?
That was a, commercial motor vehicle, improper towing.
Is that up today, Heather?
I have a subpoena for that one for 12/22 at 9 AM. But then I also was just in a breakout room with somebody that was another commercial motor vehicle ticket that I had written. And that one was for prohibited truck route, but I never got a subpoena for that one. So I don't know what happened to that guy, where he went.
It's right here.
Okay.
The other one you said, Judge, was Lamar Chase. Is that correct,
Okay.
Officer Van?
Lamar Marks, M as in Mary, ARKS.
He's in the bathroom. He's coming in.
Yeah, we need those.
So somehow I got that file for,
That's all right. We just need whatever Sergeant Van has.
okay,
He's been waiting out here and,
okay.
let's do Lamar Marks. 25W840407. Where's Mr. Marks at? Is he on Zoom? Is he on Zoom?
Is that the one no, he checked in with me.
No, he's not, Joe.
Marks? My Nicole Bailey. 5G306372B. Your name?
Emily Casino?
She pled guilty to all 3 counts. Your name, ma'am? I ordered this July 31. Why haven't you done the anger management program? And why didn't you show up for your probation visit? And why didn't you pay your fines timely?
So the anger management, I've not had the extra money with paying the fines, because I only get a 300 check every week. So I was really focused on paying the fines first. And then this Friday, actually, I was gonna pay for the anger management class. And then probation, I was in a mental institution for a week, and then I went back to work and it just completely passed my mind.
Okay, I got it. So, have you paid all your fines?
Yeah, my fines are all paid.
Why did you,
The 18th, I wanna say, I think so.
and you weren't here for your appointment because,
I just got out of the next hospital.
okay, I got it. All right. All right, here's what I'm gonna do. I'm just gonna give her more time.
That's really the reason I issued it, because I don't.
You have,
They offer the anger management program every other month.
right, so I'm gonna extend probation though, because I gave you 6 months. It's gonna be 5 months, December 31.
That's fine.
So I'll extend it for a period of 1 month. Is that gonna be sufficient?
As long as she gets into the next one, I think it's the end of January.
Can you get into that?
Yeah,
I'll extend it 1 month until February 28th. I won't assess additional costs. defendant to complete anger management program. Now listen, we have to move the review hearing date, Heather. So we're gonna have to review, because she's scheduled for January 22, and it certainly doesn't look like she's going to be done with it by then. So I'll extend the probation review hearing date for you. We'll do that like mid-February. I do have to charge you additional costs on the probation fees of $20, okay?
Okay.
All right, so do you have a date like the third week of February, Heather?
This is a Gibraltar case, so
Correct.
we have Gibraltar here on the 12th and the 26th in February.
Well,
I was thinking we should go to 26 just in case, but I
Okay.
don't know the date.
we'll go to February 26th, Heather, at 9 o'clock in the morning. Okay, ma'am? All right, so get in the anger management program, though. Make sure you do that. Are all of your fines paid?
Yeah.
All right, I wish you well. Merry
Thank you.
Christmas to you. Good luck. Thank you. Do I have LA Marks in here? Where'd this get,
Marks.
come on. LA Marks, 25W840407. Come on up to the podium, sir, state your name.
LA Marks.
You now want to plead to impeding, is that right?
Yes.
To that charge, responsible or not responsible?
Responsible.
All right, this is a commercial vehicle, 220, please accept it. Merry Christmas, original charge dismissed.
Trusted cars, those on there.
How much do you have today, sir? You have anything today?
I'm good at this Christmas shop.
All right, good enough. When can you pay this?
And the city calendar, like the 9th of next month.
All of it?
Yeah.
I'll give you till the 16th. How's that? If you don't have the money, no problem. Just call the court. We'll go on Zoom. I'll be glad to give you an extension, but it's due on the 16th, all right?
Okay, thank you.
Merry Christmas to you. Thank you. All right, now what other one do I have to get you out of here on? What is
I
the
don't
other
remember
one?
his name because I never got a subpoena on it. It was a guy out of New York. And I
Who's out
talked
of
to
New-
him. He's on Zoom, I know.
That's
Okay.
Joseph Payne.
Did he meet with the? Do you have a Joseph Bean down there? Can you check over there by John's? Is that a civil, that's a civil infraction? Oh, there he is. Okay, I gotta find the file. All right. He's bringing the file in. Be right with you guys. Kimberly Jean Cason. 25T 646 663. Good morning. Your name?
Kimberly.
All right, so you're gonna plead to impeding traffic, right? And they're going to dismiss the speed. That's what you want to do?
Yes.
To the charge of impeding responsible or not responsible. Please accepted, 150. Original charge dismissed. You're all set. Merry Christmas. Go down the hall and pay that and you're all set. Thank you. Sandra K. Aldridge, 25T 6470669. Good morning, ma'am. Your name?
Sandra Kayla.
All right, you're going to plead to impeding, right?
Yeah.
All right, to that charge of impeding traffic, responsible or not responsible? I'll accept the plea, dismiss the original charge, 150. Merry Christmas. Right down the end of the hall. Thank you. Joseph Payne. Joseph Daniel Payne, 25W840968. Your name, Mr. Payne?
Joseph Payne.
Sergeant, your name?
Dean Van Woodhaven Police.
All right, this is a prohibited truck route. Did you two talk or do you want to offer him something now?
Yes, Your Honor, we did speak and I would like to amend the violation to a CMV impeding traffic.
Okay, is that what you want to do, sir?
Yeah, no points, no.
To
So
the
yes, sir.
charge impeding traffic, commercial vehicle, responsible or not responsible?
Responsible.
Please accepted, 215, original charge dismissed. You can go on 33court.com and make your payment. Merry Christmas to you. Thank you.
You as well.
People against Ali Baydoun. Ali Mohammed Baydoun, 25F245196. Merry Christmas, Sergeant.
Hey, thank you, Your Honor. Merry Christmas to you as well. Thank
Your
you.
name?
Unmuted.
You're going to plead to impeding, right?
Yep.
All right, responsible or not responsible to that? Let me just check something. Yeah, so his conviction has to come off or come off. He tendered a plea, he filed a request to withdraw admission. I set it for hearing. So admission withdrawn. And now you're gonna plead to impeding, true? Right? To that, is that right?
Yep.
To that charge, responsible or not responsible?
Responsible.
You gotta slow down too. How much did he pay on this, Heather?
190, Judge.
Sir.
I'll make it 170. We're gonna go ahead and refund the balance, okay? So you go down the hall and make arrangements with them to do that, okay? Best of luck. Merry Christmas, happy holidays. Thank you. All right, let's do Prince, Kevin Giron, Daryl Prince. Kevin Giron, Daryl Prince. 25B726159. I don't know, is this up today, Heather? I think,
I believe it was taken for me to swear out on a bond violation, Judge.
yeah,
Well, yeah, she just needs that.
yeah, we're gonna need to bring Emily in again. Anwar, Izzy, Najee L. Kali, 25T647173. Good morning, sir. Come on up to the podium. Your name?
My name is Daniel Academy.
All right, so you're going to plead to impeding traffic, right?
Yeah.
Responsible or not responsible to that? Responsible? Is that what you want to do? And then I'm going to dismiss the point violation, the stop sign, 0 points, won't go on your record.
Okay.
To the charge impeding traffic, do you plead responsible?
Responsible.
I'll accept the plea 150. You can go down the end of the hall and make your payment. Good luck.
Thank you so much.
Timothy Boyd Jr., 25W840. 508. Good morning.
Over.
Your name?
Timothy Boyd.
How you doing, Mr. Boyd?
Doing okay. How you doing?
What are you doing? You're filing a motion to set aside default judgment. Are you in high school?
No.
Huh?
No.
Well,
I'm not.
you were born, did you just graduate?
Yeah.
What are you doing now?
Working.
Lions could use you on the offensive line or something. So you're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
All right, 165 is your total. We're just gonna double check and make sure that you, yeah, that's in your name. So you go down the hall and work that out with them. You're just gonna sign over your bond.
Okay.
Okay?
Thank you.
Merry Christmas, you too. Veronica Renee Fitzgerald, 25T647064. How you doing? Not too bad. Your name? You are going to plead to impeding, right? I need, there was another car involved.
Yes.
I'm gonna need you. Who has Trenton's today? Who's doing the department rep? Are you?
I'll be me, Your Honor.
I just need to make sure that this one was not, no minor damage and no serious injuries.
There were no injuries, Your Honor.
And no just minor damage?
Her car was disabled damage according to the crash,
That's okay.
and the other one was towed because the bumper was jammed in the wheel.
Why don't you write that on the stip form, okay? And ma'am, you're gonna plead to impeding, right?
Yeah.
That's what you offered her, right?
Yes, Your Honor.
To that charge, ma'am, responsible or not responsible? You gotta be careful, okay?
Yes, sir.
All right, 195, please accept it. Fear to stop assured clear distance is dismissed. I wish you well. Merry Christmas. You can move it out in the hall and take care of that. Good luck. Kevin Prince, Kevin Geron, Daryl Prince, 25B726. 159. Your name?
I would like to see him.
What are we doing on this one? I saw I issued a I put, You swore one in, right, on the 9th or the 16th?
We had it on the 16th.
I had a hearing?
Yep.
And now he's got another bond violation? I need a first, or another page. No, I can do it here. Raise your right hand. You solemnly swear affirm that the penalties incurred with testimony given these proceedings be the whole true self you got. All right, go ahead.
So you saw him on December 16th of 25 for the bond violation. You ordered that he go and test that DNA that day. It was not a day his color was called, but he didn't go.
He did not appear for testing as ordered on the 7th, on the,
6th. He contacted me, he got stuck by a train, and then DNA was closed on the 17th. So,
when's he coming in to see me?
he, with the holidays, he's scheduled for sentencing on January 7th.
What's he doing? Why didn't he show up? Do you have any valid explanation besides stuck by a train?
He did email me, he said he got stuck by the train, then he missed the hours, he thought they went to 9.
Sir?
That he thought they went to 9, and then again, he tried to go the 17th, DNA was closed, so he tested the first day they were open, the 18th. He is on a sober link, his sober link has been highlighted.
Who's his lawyer? House counsel? What are we gonna do now?
I don't know if you wanna just set it with the sentencing and we can see how he does the next couple of weeks. He is in treatment. He's doing everything else.
All right.
He did pick up a second job. I don't know if that's in his.
I'm not gonna issue a warrant. Don't issue a warrant on this, but I find by a preponderance of the evidence that he did not appear for testing as ordered on December 16th. Hearing to be held, you said January 6th, right? 7th. Same date as his sentencing. Better call him, tell him the judge is not enthralled with his inability to comply. You better make sure he tests every time between now and sentencing. Thank you very much. Courtney Gardner, 25W840707. All right, your name? You're gonna plead the expired plate to that charge, responsible or not responsible?
Responsible.
Why didn't you renew your plate, ma'am?
It was a misunderstanding. It was one of those. I thought my husband did it, he thought I did it, but we are current now. I immediately went and put it and then, they're current.
Okay. So you have your registration with you? I'll believe you. You got a clean record. You seem nervous. Don't be nervous. Why are you nervous? I'm not as bad as they say. $100. Good luck. Thank you. Have a great Christmas, ma'am. Good luck. Are we ready on Chowdhury and Car City? We ready on that?
Yes, Your Honor, if we want to recall it.
Tanvir Chowdhury versus Car City Complete LLC, 2504462. Your name, sir?
Good morning, Your Honor. It's Tanvir Chowdhury.
Mr. Ivanchek?
Oh, yeah, sorry. Good morning, Your Honor. John Ivanchuk on behalf of the plaintiff moving party.
Mr. Eunice?
Good morning, Your Honor. Bassam Eunice, PA 5962, appearing on behalf of the defendant, Car City Complete.
Is somebody from your client coming in?
Yes, my client's on the Zoom.
Well, he's got to start his video and tell me his name.
Okay.
Sir, start your video and tell me your name, please.
My name is Ehab Kalani. I'm trying to get the video.
Any resolution, gentlemen?
Unfortunately, no, Your Honor. We did discuss this for quite a bit of time. I did discuss it with my client for quite a bit of time. Mr. Eunice discussed it with his client for quite a bit of time, and we've been trying to reach a resolution, but unfortunately, we cannot. At this point, the vehicle that is the subject of this claim delivery case is still in the possession of the defendant. The defendant's refusing to turn it over because essentially there's a dispute between for the bill. And that's where we're at. And my client had agreed to pay $2,076. The last invoice that was received was for roughly $3,000. And that's where we're at.
So they're $1,000 apart?
Yeah.
Yes, Your Honor.
Your Honor, the initial bill was for $5,000. It was discounted to $3,000, and now they're about $1,000 apart on where they're at. As Mr. Ivanchek had indicated, so they had just filed this motion for possession pending judgment, which to me is really a summary judgment motion disguised as a motion for possession because their entire basis for their complaint is a claim and delivery complaint. My understanding is that there was initial quote provided for about $1,500 to $1,000 or to $2,000. Since then, there were change order work modifications that were requested by the plaintiff. Those modifications and the pricing for those respective modifications were agreed on verbally and memorialized via text messages sporadically during the time the car was in the shop. And as I explained to John, I mean, my clients have a statutory right to retain the vehicle under Section 3 of the Garage Keeper Lien Act. Storage fees are allowed to be charged, and that we're just kind of at a situation where they would like the car released, and then there's a dispute on.
Guys, you can resolve this. Are the extra charges just for the storage? Wait a minute, no.
Unfortunately.
Wait, no. You got a good lawyer here. Are the extra charges just for storage?
No, Your Honor, they're not. If you take off the storage charges, that's where we get the $1,000. And essentially, yeah, I mean, the problem we have is that we don't know what the starting point was other than in terms of what the work was supposed to be done. But the price was agreed upon for $1,500. And then there was an extra that my client did agree to pay, which brought us to around $2,000. But then it's the rest of it after that. That's where the dispute lies. And unfortunately, I was hoping counsel would be able to provide some clarification for this over the weekend of, documents one way or the other to say, hey, here's
Look, let me stop you guys. I signed a restraining order. Your client, Mr. Eunice, is prohibited from violating that restraining order, which prohibits him from either concealing, disposing of, destroying the value of the vehicle. I'm
Understood.
thinking maybe we should just set this for trial and I'll keep that temporary restraining order in effect. Anybody disagree with that? I mean, it seems like you guys should be able to resolve it, but I don't know what other way to go. You have been here now. It is only your first time, Mr. Eunice. I had to adjourn this from November 17th. And I told Mr. Kildani he needed a lawyer. And then I adjourned it again until today. I think he still didn't have one. And then that's where we are. So you guys, unless you have other ideas,
Your Honor,
wait a minute. Your client wants to speak, Mr. Ivanchek. Do you want him to speak?
or not, but he wants to do what he wants to do.
Good.
One thing I would like to say, Your Honor, is that it's been 6 months. We've been without a vehicle. My vehicle, I got 4 children, like I've said. Now, my vehicle was ready to be picked up. It was all done on September 19th. I have text messages here. It said, your vehicle is ready. Come pick it up. I never refused to pay that. Although the initial was $1,500, I said I would pay the $2,076. It's right here. I went there to pick it up. I could have paid it that day, drove my vehicle home, but it looked like some kid just took it in the store, in the garage, and they messed my vehicle up. They didn't put the striping back on. There was defects. That was the reason why it stayed there 1 week extra for them to fix it. But then when I come back to get it, after they fixed whatever issues there was, it jumped to $3,000. Otherwise, on the 19th
Of September.
19th of September, I would have paid $2,076.
And walked out of there.
Yes.
Well, did they screw something up here, Mr. Eunice?
that's
My
not true,
understand-
sir.
Frank, I got it. Your Honor, there's a itemized breakdown of all of the modifications that were made to the vehicle. So, brother counsel had indicated that we got to the $3,000 on the difference of the storage fees. That is not true. The overall bill is a total of $5,000 and some change. It was discounted to $3,000 after plaintiff's repeated request for a discount due to, it taking a little bit of time. a little bit more time than was expected. My clients graciously agreed, provided them the $2,000 discount, and now we're at $3,000. You know, this song and dance of, let's add the storage fees, and that's how we got to $3,000. That's just simply not true. The bill's for $5,000.
So you guys are at $1,000 apart, right? That's it.
Yes,
I don't want, I'm gonna be the fact finder here. I don't want to be involved in this too much. In your settlement negotiations.
Yeah,
Right.
I can't do that. I'm not supposed to do that. I'm not gonna start today. So I
Yeah.
will do whatever you guys want. I'll give you another pretrial, or I can understand this gentleman's position. He's been without a car since at least September 15th.
July.
well,
July.
Your Honor, to that end, just as a suggestion of maybe what we could do here, my client has agreed to pay $2,076. Opposing counsel or Mr. Eunice's opposing position on that is that, that he doesn't want his client to lose his lien. However, as the court's aware, we're all under the jurisdiction of this court. So if my client were to go pay $2,076 today, the defendant can release the car. We can set it for trial for the remaining amount under penalty of show cause if my client does not pay what the court ultimately
I
decides.
got a better idea then. Why doesn't your client pay the remaining balance into escrow into the court? They think it's 3,000, so he could go get the car for 2,076. If
Okay,
it's $3,000 equal, the order can reflect, this is just a thought, that he paid $924 into escrow. And that is to be turned over following a determination by the court, whether or not the the defendant's entitled to that, the plaintiff's entitled to that. And we'll have a hearing and a trial, and then I can just decide it. Is that fair with you, Mr. Eunice?
Yes, Your Honor, with the only request being that the escrowed amount total the full 5,000, because the discounted amount was made only as a courtesy to the client for the time. If he's disagreeable to the $3,000 amount, and we're working within the plaintiff's framework of what he believes is owed, I prefer that escrowed amount be the full 5,000 for what work my clients actually put in. I mean, this isn't a $3,000 bill. It's a $5,000 bill that was discounted as a courtesy to the plaintiff.
Now, unless they're relatives, most people don't just discount from 5 to 3 as a courtesy. There's got to be other reasons, okay? So maybe that's entirely accurate. Maybe he's just a very generous man. That is your client, Car City Complete. Maybe they are over the top generous. But
okay.
I highly doubt that he just did it as a courtesy, discounted it by 40%. I mean, come on. Look, I'm going to do what you guys want, but I'm not going to get involved in your settlement negotiations any more than I already have. So I will do whatever you want. You want me to set it for trial? I'll set it for trial. I can do it early January, probably the second, third week. I can set it for trial. You guys can all come in and you can pay your lawyers a ton of money to come in here at whatever they're making. And nobody's going to be a winner. I could care less. I'm here. I'll hear your case, but you can't. I mean, sometimes we win the battle and lose the war. I mean, so to speak. I'm just telling you, these guys went to school. They're entitled to the money they make, and they are not cheap. Hang on. I just want to say, so what I want me to do, you want me to set it for trial, or you guys want to try to resolve it? I can put you back in a breakout room. I can set it for trial the second or third week of January and a final pretrial where you two can talk. All 4 of you on Zoom, or the 2 of you lawyers, and I'll set that for the first or second week of December, and then the trial the week after.
I think Mr. Eunice's client wanted to say something, maybe to his attorney. I'm not sure.
You want to talk to your lawyer, and I don't want you to talk to your lawyer in front of me, Mr. Kildani. I don't want you to talk to your lawyer in front of me. If you
I
want,
understand, sir. No,
I could put you in a breakout room and you guys can talk, and I'll go on to these other cases. I'll be here all day. Okay?
all right.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Thank
Why
Your
don't you
Honor.
put them back in a breakout room, Heather? Thank you, or
I will,
Jennifer,
Judge.
whoever. Thank you. All right, you can go talk to your lawyer further. I wish you guys well. Nathan Harley Williams, 25T647201. Could I have Michael Mayali and John Wolf both seated at the table here? Good, sir, your name? You're going to plead to impeding traffic, true?
Sure.
Yeah,
Excuse my voice, I've got sinus.
don't worry about it. I've been hacked in the morning to the charge of impeding traffic, responsible or not responsible. I'll accept the plea to impeding, dismiss the original charge, 150. Cash your end of the hall to your right. Wish you well.
Thank you.
Merry Christmas. Michael Mayali,
Sure.
25W840967. Your name?
Michael Haley?
You're gonna plead the commercial motor vehicle impeding, right?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Please accept it. It's commercial vehicle 220. Cash your end of the hall to your right. Merry Christmas. Good luck.
Okay,
John,
I was gonna see if I can get it extended till after January.
you have anything you can pay today?
Nothing, I just spent all my money on Christmas shopping.
All right, good enough. Can you pay by the 16th, you think?
Yes.
Make it January 16th.
All right, thank you.
And if you don't have the money, no problem. Just call the court. We'll go on Zoom like this. I'll be glad to give you an extension, okay? All right. Have a nice Christmas. John Wolf, 25W84672. Defendant failed to appear. He's responsible as charged by default. Mohammed Asghar, 25W8406764. He failed to appear. This was scheduled for 9:15. He's responsible as charged by default. Muhammad Ali, 25W84074. He failed to appear. Default judgment. Come on back in. Chowdhury versus Car City, 2504462. Names again, please.
Continuing appearance of John Ivanchuk on behalf of the plaintiff, Your Honor, who's there in person.
Bassam Eunice on behalf of defendant, Car City Complete.
Your name, sir?
Cambridge Harvard.
Mr. Kildani. You
Yes,
gotta-
sir.
Come on, please. Thank you. Your name?
Ehab Kildani.
What are we doing?
Well, Your Honor, we've discussed this and we've reached a resolution. I can put the terms on the record really quick if it's okay with the court. So my client will pay the amount of $2,500 in cash. The defendant will provide a receipt and release the car.
In Your Honor, we'd prefer that to be done within, 3 days? Is that fine?
Yeah, I
7
don't
days.
think that's an issue. Mr. Chowdhury, is that a problem?
No, it's not.
Okay.
Thank you.
Maybe.
All right,
Or-
so then everybody agrees that the defendant is going to pay, that Mr. Chowdhury is going to pay Car City Complete $2,500 in cash within 3 days. The car will be released to him and the parties will stipulate to dismiss this case with prejudice. Is that right, Mr. Ivanchuk?
Why don't we set it for honor before December 24th? Because 3 days would be the 25th, I think, right?
Okay. Can you go over there today? Can you get the 2,500 and go over there today?
I want that car right now.
Can you get it today?
Yeah.
Okay,
Frank,
so we'll say on or before the
Yes.
24th. Is that good, Mr. Eunice?
Yep, beautiful.
Is that good, Mr.
Yes, sir.
Chowdhury? All right, then you guys will submit a stip in order to dismiss the case with prejudice today, right?
Once he picks up the car
Yeah.
and and the defendant will provide a receipt of the 2,500, Your Honor.
Right, so you're gonna pay him in cash. He's gonna give you a receipt, okay?
Thank you, Thank you, Mr. Venture.
All right, thank you all.
Thank you.
All
Happy
right, thank
holidays,
you.
gentlemen. Thank you very much.
Merry
You as
Christmas.
well. Happy holidays. Merry Christmas.
Thank you, Your Honor.
Thank you
for
very
your
much.
patience.
Okay, guys, I'm gonna move you out of here now. Mark Green, 25T647213. I'd like Jeremy LaForest up here, seated at the table, my right, your left. Jeremy LaForest. I don't know why all these guys are here. Your name's,
Mark Green.
you're gonna plead to impeding, right?
Yes.
Is that what you want to do?
Yes.
To that charge, responsible or not responsible? All right, total fines and costs are 170. How much can you pay anything today?
No, I
When
don't
can you pay this?
talk to the officer. I don't know. My house like that. I lost my job. I told him, I don't know. I really don't know.
Your house burned down?
Yeah, it's been just a disaster. One thing after another, then a guy crashed into it, then,
I'll make it February the 6th. If you don't have the money, you come talk to me on or before that date or call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you.
Fair enough?
Thank you.
Merry Christmas. I'm sorry you're going through that. Jeremy Roy LaForest, 25T 646-641. Defendant failed to appear. Fault judgments entered in favor of the plaintiff and against the defendant. All right. People against Milat, Bradley Jacob Milat, 25 W838481. Name?
Bradley Mott.
You're charged with a violation of probation. You have two charges. Count one, failure to attend the positive strategies program with 4-week follow-up. That's count one. Count two, you failed to pay your fines and costs as ordered. Balance as of the writing of the show cause, $435. If you plead guilty or if you're found guilty of those, you could get 10 days in jail. Do you understand that?
Yes, sir.
Did you sign an advice of rights and read and understand the rights?
Yes.
If you, did you give them an advice of rights?
Yeah,
Where is it?
quick copy.
I don't know where it is. I'm gonna need that up here. If you plead guilty here, you'll be giving up all the rights on the advice of rights, and there will be no hearing. Do you understand that?
Yes.
All right, you have the right to an attorney. If you cannot afford one, I will appoint you one at public expense.
He's already met with Mr.
Well, I'm gonna need Mr. Haynes in.
He's the son of your
Why don't you have a seat? All right. Jonathan Johnson. People against Jonathan Johnson. 2-5. Is this with Mr. Gates?
They're all with Mr. Haynes. He's finished up with one more person.
All right. So we don't have any. Right? Does Mr. Stefani have Mr. Haynes too?
They all have him. He's ready on all the other ones. He's just finished up with Mr. Hall.
All right, people against Malat, Bradley Jacob Malat, 25W838-481. I'll need Ms. Wilds on this. Your name, sir?
Bradley Mott.
Two charges, failure to attend the positive strategies program with 4-week follow-up and failure to pay your fines and costs as ordered. Mr. Haynes,
Your Honor, good morning. For what names we have Mr. Mamaki pleading guilty to the violation.
is that what you want to do, sir?
Yes.
If you plead guilty, you could get 10 days. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights? If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
Is the count one that you failed to attend the positive strategies program with 4-week follow-up? How do you plead?
Guilty.
Do you fail to attend that?
Yes.
Count two that you failed, pay your fines and costs as ordered. How do you plead?
Not guilty. On that date, as of maybe, yes, I did.
Did you fail to pay your fines and costs as you were ordered to? I can't hear you.
Yes.
Anybody force you to plead guilty?
No.
Please are accepted to those two counts. Let's move on to another one. Have a seat right behind you there. I'm gonna need Jonathan Patrick Johnson, and that's Emily on that one. 25B1489318.
Good morning, we have Jonathan Johnson.
Name, sir? Okay. What are we doing on this one?
Just got 12 violations. Number 5 and number 7 are duplicates. They're the exact same thing, same date and time. But he is pleading guilty to the violations. It's a combination of positives for alcohol and for mis-sober tests.
If you plead guilty, so I'll just dismiss count 7. Is that fair?
That's fine.
So he's gonna plead to 1 through 6 and 8 through 12.
Yes.
If you plead guilty here, sir, your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that? I can't hear you. Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights. And there will not be a hearing. Do you understand that? I gotta keep your voice up for me, sir. Did you hear what I said?
Yes, sir.
You gotta keep your voice up for me. You understand everything I've said? As to count 1 that you failed. Just give me 1 second. Failed to submit to 7 a.m. PBT on December 12 of 25. How do you plead?
Guilty.
And that's on the sober link, and that was on December 12, right?
Yes, sir.
Did you fail to do that?
Yes, sir.
Count 2 that you submitted a breath test through a sober link on December 13th with positive results. So that would be failing to refrain from consuming alcohol. How do you plead? Did you fail to refrain from consuming alcohol on the 13th?
Yes, sir.
Count 3 that you failed to refrain from consuming alcohol, testing positive again on December 14th. How do you plead? Did you consume alcohol, say again on that date?
It was open 72 hours.
I didn't ask you that. Did you test positive for that and consume alcohol on the 14th?
Positive, yes.
Count 4 to the charge you failed to refrain from consuming alcohol, submitting to a breath test with positive results on December 15th. How do you plead?
Guilty.
Did you test positive that date?
Yes.
Count 5 that you failed to submit to a 7 a.m. PBT on sober link on December 18th. How do you plead?
Guilty.
I need Emily in here on this one. Count 6 that you failed to refrain from consuming alcohol, having a positive result on December 16th. How do you plead?
Guilty.
Count 8 that you failed to submit to a PBT on December 18th. How do you plead? Count 9 that did you fail to do that? Yes?
Yes, sir.
Count 9 that you failed to submit to a 7 a.m. PBT on December 20. How do you plead?
Guilty.
Fail to do that?
Yes, sir.
Count 10 that you failed to refrain from consuming alcohol, testing positive on December 20. How do you plead? Failed to do that?
Yes, sir.
Count 11, you failed to submit to 7 a.m. PBT on sober link on December 21. How do you plead?
Guilty.
Fail to do that? Count 12 that you failed to refrain from consuming alcohol, testing positive for alcohol on those dates in time. That date, December 21, at 9:04, 9:18, 9:48, October 18, October 48. I'm sorry, 10:48, 11:31, and then missed on 11:48. How do you plead?
Yes, guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty? Please are accepted the counts 1 through 12 with the exception of 7. Count 7 is dismissed. It's a duplicate. I think I need Ms. DeCino to tell you what's going on in this. Your name?
Emily Casino?
How disappointing. What would you like to say? I want you to tell Mr. Haynes from the beginning what has happened on this.
So he is scheduled for sentencing on 2 separate show causes on January 14th. There were similar issues, and he was saying that there was something was wrong with the device, so we got him a new device. And they sent his other device out to have it checked if there's anything wrong with it. And then got the new device and we're happy.
So either he should go play the lottery Cause I've never had, I don't remember having somebody have have a malfunctioning device of any kind. Maybe there was. But for someone to have two, one ticket, 150 million. I can't wait to hear, because I am really upset with Mr. Johnson. He gets in sobriety court. We told him it was a marathon. He didn't even get to the end of the sidewalk up here and he's basically quit. Go ahead, I want to hear.
Yes, Judge, and I don't have the particulars on the hearing that's coming up, but in talking to Mr. Johnson, he's been pretty direct and candid. He's struggling with alcohol.
He lied to me under oath. He lied to me under oath. I want to repeat what I said. He lied to me under oath. I gave him every opportunity to come clean, and you lied to me under oath. You got no business being in sobriety court. We made a massive mistake on this one. What a failure on our part to see through the nonsensical garbage. And I, as the head of this sobriety court, accept full responsibility. You lied to me under oath. You don't lie in a courtroom, son. I don't care what it is. You want to tell me I'm struggling? I'd have been so understanding, it wouldn't have even been funny. You don't lie to the judge and you don't lie when you're under oath and you hit both. I feel like terminating him right now. That's how upset I am with him. I really do. I mean, I'm just ready to go give him 93 days and let's move on. I will not tolerate people lying to the courthouse, not me. It's not about me. Not about me. You don't lie to the judicial system under oath. You don't do it. I gave him every opportunity to get off the mat. No. It's a malfunction. It's a malfunction. So I got to have people from house arrest take time from their day to come on. We got to fool around with switching out devices. And then the same thing happens. And I'm telling you, if this was a malfunctioning device, not one, but two, he needs to go buy a lottery ticket. He'll be a billionaire by 6 o'clock or whenever the next drawing is. Unless you think I shouldn't terminate him, I'm doing it right now.
Did he plead guilty?
Yeah, he's pled guilty to all these. And now his lawyer started out, Mr. Haynes, a gentleman, he's struggling with alcohol, which is what I knew from the beginning, but he wouldn't tell me that. He wanted to lie to me. He wanted to assure me he didn't. I told him, you're not going to testify falsely under oath. Go ahead.
Judge, you've been around this even a little longer than I have with this a long time. With this particular problem, you don't know when people are ready. You know when they admit it. You know when they see the light. A lot of times people have done a long time trying to get away with things and it becomes a habit. Today, and this is not around for the other part of this, I met Mr. Johnson for the first time today. We talked about it and pretty quickly we got to the point. He has been involved in counseling with the GARA. I'm hoping the court will order that his counseling is increased, possibly intensive outpatient, because he is struggling with that degree and he needs the help. I don't know exactly what's going on with him in his personal life, but he does have a job. He works at the call center, gets off at midnight. He says he's doing his meetings after that. He's working toward getting a sponsor, but he doesn't have one yet. And maybe getting a sponsor would be the part of this that helps make a difference for him. But if he's made a step today that he's acknowledging this, I hope he gets a chance.
Anything else that you want to say, sir?
Now, give me this option. I won't fail. I won't fail people.
Anything you want to say?
Yes, I am with Mr. Hayes in some capacity that I don't think it's uncommon for the early days for people to fight it. I think it is a step in the direction that he was at least honest today. I'm equally as frustrated when I think of the work I put into the other violation. To wise. I'm kind of thinking that maybe a scram tether would be appropriate because now we're having an issue that he's missing the 7 and 11 AM one. And then I would definitely want to speak to Hagera about getting him into IOP and maybe an MAT consultation. And the ETG did come back and confirm I got it today for the record.
I just don't understand. I just don't understand how when a judge lets you off the mat, and I did let you off the mat. I mean, I told you not to lie to me, and you lied under oath. I get the whole addiction thing. We all get that. Every one of us get that. I don't understand how when I was talking to you and I knew you were lying and you kept assuring me you weren't lying and you testified under oath. I would not blame myself for sending you away today for 93 days. I want to be clear about that. You just got started in this program. And you aren't even giving it a shot. And again, I get the addiction thing. We all understand that people are going to fail. They're going to relapse. I get it. But you went to such great lengths. I'm going to have a hard time forgiving you for that. I mean, you really went to great lengths. But that being said, here's what I'm doing. You're to serve 10 days jail now. I don't care who you're going to be with or not with on Christmas. That's just too bad. That's just too bad. You're going to serve Christmas Day in jail. And for you to make me do that, for me to do that, you really pushed me. You ought to know that. You're to have a MAT consultation. You're to convert to a scram tether first business day following release. So we can even take the sober link that he's on. I don't know where he got it, if he got it from house arrest. Pardon?
He'll have to take it to house, if he doesn't have it with him today, he can bring.
Do you have it?
I would rather him keep it almost, so that when he gets out.
It's going to be.
What if he gets out at 7 PM on a Saturday,
That's fine. I'll let you work on that. You're going to return that. We're going to give you a scram tether, 10 days jail, 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. This is basically, there's no basically about it. This is your last chance. You lie to me again, we're done. Good luck. That's what we'll do. And you can talk to Gary about IOP, intensifying the treatment. I do. And we'll see how things go. Thank you very much. People against Bradley Jacob Malat, 25W838481. Your name? Ms. Wild, your name?
Elizabeth Wilds, probation, Your Honor.
James? All right, I sentenced him June 25th, 12 months probation. Why has he done the positive strategies? And where do we stand with the,
Money's been paid, Judge.
okay.
Ms. Wilds, it's in the system. They had shortly after the violation was filed. Ms. Wilds has indicated the next time is January 22nd for the positive strategy program. We make no excuse for that not being done yet, but he will be able to enroll and do it that day.
What do you think, Ms. Wilds?
Yes, Your Honor, I kind of agree with what you started off. It's been a minute. I have given Mr. Millat the information a few times in regards to the program. At the last visit I had with him, I told him I couldn't afford to give him any more time to do the program. Mr. Haynes is correct. I did let him know that the next scheduled one through PERS is January 22. I don't think it's without reason to give him a few extra days on the court work program as penalty for kind of dragging his feet, Your Honor.
Yeah, I agree. Anything? You're gonna pay costs of $100. You are to serve 1 day on court work program and pay $35 for that and pay $35 for that. You gotta be more diligent, young man, okay? So we'll set you up for the day on the court work. I'll send him over there now to set that up with you, Ms. Wiles.
Yes.
And you can pay the $35 now.
Yeah.
All right, make sure you take care of the program. Good luck. Thank you. Anthony Stefani. Anthony Joseph Stefani, 25W701244.
With his Anthony Stefani.
All right. Come on up here, Mr. Stefani. I have a probation violation from November 20. He entered a not guilty plea. There's a charge of failure to pay fines and costs and failure to refrain from violating a law, being convicted of public intoxication, offense date November 5, conviction date November 20. Your name, sir?
Anthony Joseph.
How is he going to proceed now?
Pleading guilty to the bar.
All right, can you, Ms. Wiles, I'm gonna need you on this one too. Is that what you want to do, sir?
So,
I'm sorry?
I believe so.
All right, if you plead guilty, I want to make sure that's what you want to do.
So if you want to do it, Mr. Stefani? Not really. Did you not pick up a new case, Mr. Stefani? Yes, I did. You pleading guilty? Yes.
If you plead guilty here, you could get 10 days. Do you understand that?
Understood, sir.
Did you sign the advice of rights and read and understand the rights?
Sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, as to count 1 that you failed to pay your fines and costs as ordered, how do you plead?
No.
Is the count 2 that you were convicted of disorderly person, public intox while on probation? How do you plead?
No.
Were you convicted of public intoxication, disorderly person on November 20 of 25, arising out of an incident that occurred on November 5 of 25?
Yeah.
And did you fail to pay your fines and costs?
Yes. Well, no, sir. Yes, sir. I'm late on December.
You didn't pay your fines and costs as ordered though, right?
Correct.
Anybody force you to plead guilty? I'll accept your plea, okay. To both counts. Ms. Wild, your name?
Elizabeth Wiles, probation, Your
What do
Honor.
you want to do here, Mr. Haynes? Can you make any?
Judge, right after that conviction in November, it's in November, actually, before the sentencing. He entered into quality behavioral health. There was an inpatient stay within 30 days there. Brought a certificate in and he just got out on December 12th. He set up to pointed that into through October. He had already been on a payment plan. He had been consistent with that payment plan, but he didn't pay the month when he went to the interest program. What we're asking for is for the court to accept that, that he did complete the program and allow him to start up again on his new payment plan with a payment of $100 each month starting February 1st.
Ms. Wilds, can you tell me how much he owes? Do you know? Or have
Yes, Your Honor. He owes on his probation case $1,040, 10
Still, okay, so he hasn't paid anything. When are you gonna be able to pay that, sir?
Right up to the first of the year, sir.
How are you gonna get that money?
Taxes.
Well, you're not gonna file your taxes January 1. You gotta give me a date. What's after the first of the year mean to you?
Back to work. But the gentleman that I've been doing most of my work with, he's off until the first of the year is over.
You were in custody as a result of that conviction, right? When you were convicted of that public intox, how long did you spend in jail? It seems like I had you at the county here a couple months ago, no? Am I?
That was all these
I turned myself in, I've been taking care of all my tickets, sir. I've been back and forth. Getting all this squared away. We would have been done had this not happened with this public stops. I had to pay the money and.
So you didn't really spend any time in jail in November?
Yeah, I did the day, I did the day for this. I had real bad seizure just a little bit ago, so you have to excuse me.
Take your time. It's okay. I'm just trying to figure out, it seemed like you were in custody in front of me.
Well, yeah, because I zoomed from QBH to show up for court. And you said you wanted to see me in person. Not,
All right. Do you have anything to add, Ms. Wilds?
Your Honor, I think what you're asking, so on that new offense, that one was in front of Judge Hessen. He received 1 day of credit for that offense.
It seems like he was in front of me. I saw him a lot.
we've seen each other a lot this year, sir.
Yeah, he's been on probation since March. He absconded, Your Honor, and then he was in front of you. Got placed, not back on probation, but probation resumed. He was actually supposed to do his education program October 7th. He did provide a medical, so we were going to allow him to do that program in December. But he went out and he picked up this new offense, the disorderly that he's violated for. And right after that, he entered in at QBH.
All right. You said you can pay it right after the first of the year. You really don't mean by January 5th. You mean by when? February 1?
First? Yes, sir. And yes.
But-
I need the month of February to pay. I need the month of January to get paid.
You pay this in full by February 1. Judge Hessen presumably took care of whatever punishment was deserved on the other. I'm gonna go ahead and let it go with that. Let's get your life back in order though, Mr. Stefani, okay, please? All right? And now, if you need more time, if you don't have the money, it's not a problem. Just call the court. We'll go on Zoom or walk in here on before the due date. I'll give you an extension.
Judge, I wasn't aware that he was waiting on a tax refund to take care of this. We have March 1st instead of February 1st.
Well, he's got probation coming up when? Is that what you're gonna do, is with your tax returns?
Well, that's what I was planning on.
All right, we'll do it March 1. You just gotta diary that up, Ms. Wilds, because probation ends March 18th. So if we don't have it March 1, we're gonna have to show cause them, okay? If you need more time, you call the court, we'll go on Zoom, all right? Or you can come in here on it before that due date, and I'll give you an extension. Good luck. Merry Christmas to you. Thank you. Stay out of trouble now, please.
That's it.
Thank you.
Thank you, Judge.
Thanks, Ms. Wilds. I think that's it for you, or you got another one?
Dylan Hall.
Dylan Hall, Dylan James Hall. 25B148235 A and B.
No one has to have Dylan Hall.
Sir, your name?
Dylan James Hall.
So he had a case taken under 7411 and HIDA, right? What did we do here? Let me see. You got a drug charge that was taken under 7411. You got a CCW charge taken under HIDA. And he was ordered to attend and complete the substances of abuse program. And they think he didn't complete it. How's he going to proceed on this?
Guilty.
Is that what you want to do, sir?
Yes, sir.
I'm gonna need Jessica on this. If you plead guilty, this would be your second violation. And you could get 10 days in jail. Do you understand that?
Yes, sir.
All right. Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not gonna have a trial. Do you understand that?
Yes, sir.
To the charge you failed to attend and complete the substances of abuse program, how do you plead?
Yes,
Did you fail to attend and complete that?
yes, sir.
Anybody forced you to plead guilty?
No, sir.
Just give me 1 second. You did not attend, correct?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
Why didn't you attend the program, sir? Can you tell me?
I did accidentally yesterday.
Accidentally missed it. Your name?
What's going on?
What do you want to tell me, Mr. Haynes?
that he needs to get the program done. I think it's an 8-week program. I don't know how much longer he's got on probation, but if he is gonna need an extension, we'd ask the court to extend his probation on.
July 30, you were ordered to do this. Why you been fooling around like this?
Got to get it done. I did,
Forgot to get it done.
He started the program at one point, like yesterday, so.
yeah.
What do you want to say?
Intake back in November 3rd, and then the next class didn't start until the following month, and that was when he then missed the follow-up. So he missed the follow-up for the weekly sessions on December 7th and then December 14th.
And how long is the program again?
The program's it's 8 total sessions that he has to complete. So well, technically it's 9 altogether. It's an intake and then the 8 sessions. So he's completed 1 out of 9. And I don't know when their next session starts, because right now they're in one and they're not gonna let him join in now halfway through.
Probation, he's supposed to be here
He had-
for a review hearing January 14th. So I made a mistake on this one. Give me 1 second. Okay, he was placed on probation July 30, so he's scheduled to come off January 30. I'm gonna have to extend your probation for 3 months until April the 30 of 26. Pay additional costs of 75, additional probation fees of 60, serve 1 day on the court work program, and pay $35 for that. So you owe $170. We're gonna have to remove the review hearing date, Heather, so we're gonna have to make it closer to the latter part of April.
Okay, Judge, we have Brownstown, April 22nd.
That would be good. So the new review hearing date will be April 22nd at 9 o'clock, sir. April 22nd at 9 a.m. New review hearing date. So we're going to give you that. And you're going to go down the hall, pay your 175. Do you have that? Pay that and then go back and talk to Ms. O'Donnell about setting up your court work program day. You gotta stay on this. Good luck. Merry Christmas. Thank you. Thanks, Mr. Haynes. Thanks a lot. Take care. I think so. Man, what do you have here? What do you here on?
It's 10:37.
Oh, are they here? You're all set, I think, Mr. Haynes. Is Mr. Haynes all set to go? Heather, do you know if we got all these done? I think.
I do not have anybody on Zoom, so as long as everybody in person is done.
Stu, looks like there are gonna be no shows, church and Dave's.
What time were they scheduled? We'll put them on for warrants and, yeah, you can go.
Yeah, 9:15.
Yeah, we'll just issue warrants.
Yeah, I'll do them later.
You're all set. Merry Christmas to you, Mr. Haynes. Thank you as always for your help. Are you on that are you Spicer?
Yeah.
I have Mr. Lochner in Zoom, Judge. I can let him in. I
Yeah,
wasn't
please.
aware who was in there, sorry.
John. You might need by with the motion on my desk. The trial briefing. Mr. Stevens is.
Oh, you didn't check, I didn't know who that
St.
was.
Louis, they're up at 10:30, so I need the motion on Spicer, which is on my desk. Trial brief on that one with
Is that on your desk too?
St. Louis, yeah. Do I have Capital One versus Emily Burke?
I have
25021.
plaintiff here. I don't have defendant yet.
Jeez. I don't even know what this is up for. Owner's Management versus Justice Spicer, 2502423. Come on up here, man. Mr. Lechner, your appearance?
Good morning, Your Honor. Attorney David Lechner, P number 67994, on behalf of Owners Management.
Hi.
Your name, ma'am?
Justice.
All right. No, not yet, Miss, let me, did you read her motion, Ms. Spicer's motion?
I read it, Your Honor, and before we get into it, I spoke with my clients. We're willing to withdraw our petition to reopen the case at this time and let Ms. Spicer finish out her probation. I do want to say that, just for the record, that she agreed to this probation and the probation said no violations of the lease. The lease doesn't allow for pets, whether it's her pet or I know her contention is that it was a visiting pet or she had a visitor who brought a dog over. That's still a violation of the lease. And a noise complaint, whether it's on Halloween or any other day, is still a noise complaint. So going forward, I want Ms. Spicer to be aware that although we're withdrawing it at this time, while she's on probation, any violation means any violation. Um, but at this time, we'll withdraw our petition to reopen the case.
What was the basis by which you had indicated that she did not comply with the judgment?
There was a violation for an unauthorized pet, and there was a violation for a noise complaint a noise violation late at night.
I know. Did you set those for hearing, or did you just file an affidavit of non-compliance?
I just filed an affidavit of non-compliance to reopen the case and waited for Ms. Spicer to file objections, which she did.
All right, so we're back to square one. You're withdrawing your petition to reopen the case. Your client has apparently accepted rent for December, right?
I don't know. I don't know that because we filed this back in November, so they might have put a hold on Ms. Spicer's ability to pay rent. Usually that's their standard operating procedure when there's a an action for eviction, they stop accepting rent. So I would defer to Ms. Spicer because my client's not here right now. I would ask Ms. Spicer if she was able to pay rent or not. If she wasn't, I will reach out to my client so that they open up the portal so that she can pay her December rent. We would not at this time be aggressing against her for failure to pay rent because if she didn't pay it, it was because she wasn't allowed to.
Right. She said in her response, she already paid it for December. So are
Okay,
you
then-
satisfied? They're gonna withdraw their petition to reopen the case, okay? So you are all set. Merry Christmas to you, ma'am.
Thank you, Your Honor.
Capital One versus Burke. 2502019. Mr. Saloom, your appearance.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Where is Ms. Umi? I saw her out there.
Yeah, I just spoke to her in the breakout room. Hopefully she's getting ready to
She
join.
should be coming back in. I just requested her to rejoin.
Okay.
Okay.
And we haven't been able to come to an agreement, Your Honor, so I guess we will need the court to make a determination.
I'm not even sure what you're here for. Your name-
That's a good point because technically, I guess we're here on her motion for a stay. But she wants-
Judge, excuse me, counsel, if I may.
Yeah,
This was
no
the one that we had received a motion from Ms. Verk requesting the court date moved up on her objection. The garnishment hearing, I believe it was. And
Yeah, I
you had
think
asked that I move the date up.
Right.
Ma'am, your name, ma'am.
UMMIVIRK, Umevark.
Your Honor, I think what happened is she filed a motion for installment payments scheduled for January 13th of 2026. We have no objection to that being heard today. I guess if we hear it today, then her motion for stay becomes a moot point. It's up to the court how the court wants to deal with the motion.
All right. So I'll just go ahead and hear your motion for installment payments now, ma'am, okay?
Yes.
tell me why you can't afford this. I'm vaguely remembering what you're talking about, Jennifer, but not really. I remember you talking to me about how I wanted to proceed on this with regard to moving the date up. I vaguely remember that. What are you asking to be able to pay, ma'am?
My mom is not able to speak English well, so can I speak on her behalf?
Yeah, well, what is your name?
Marine Verk.
All right, so I got to be a little careful here now. I didn't know that, or we would have gotten an interpreter. I can't really let you, can you translate for me? I can do that so I can expedite the hearing. Can you speak to her and translate? I can't let you represent her.
Yeah,
All right, so your name is Marie Verk.
Marine Verk.
How do you spell your first name?
MEHREEN.
All right. And what language do you speak? You speak English, obviously. What does your mother speak?
Urdu.
And you also, are you fluent in Urdu?
Yeah.
Any objection to me doing it this way, Mr. Sloom?
No,
I
no
mean, I
objection,
can't get
Your
an
Honor.
interpreter here this second.
No,
That's
no
the
objection,
purpose.
Your Honor. I don't think it's a real complicated matter.
Right.
I'll let, yeah, no objection.
Ms. Burke, young lady, raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the parties here. In other words, you're going to translate to your mother, you're going to translate to me and the lawyer what your mother's saying. Is you promise to tell the truth and do that and make a proper translation under oath?
I do.
Okay. Now, all right, put your hand down. Now you're going to ask your mother, you're going to repeat exactly what I say to her, and you're going to repeat exactly what she says to me. You can't engage in a side conversation with her, okay? Fair enough?
Okay.
All right, ma'am, tell me
Yes,
how
sir.
much you think you can afford to pay. You're going to tell her that.
Okay.
I can,
पुस्तक है अभी तू के लिए देने ने
I can afford at the most $20 a month.
How much?
$20 a month.
Do you
$20.
work? Wait a
Yeah,
minute, this isn't working. I thought you said she can't understand English and she's talking to me.
She can understand it, but not really well.
Well, I need you to translate for me, okay?
Okay.
Tell me why you can only afford, and you tell her this, tell me why you can only afford $20 per month.
क्योंकि मेरी minimum
तू मेनू गल क्यों नहीं करन देंदी तू ओनू 10 भी तू ओनू $20 per month क्यों सिर्फ दे सकनी है
क्योंकि मैं मिनिमम वेजेस कम करनी है तो मेरे एक्सपेंसेस बड़े ज्यादा हैं तो मैं सीखा मेरे लॉट ऑफ बिल्स ने मेडिकल बिल थेरेपी दे हेनरी फोर्ड हॉस्पिटल दे वेन मेट्रो हेल्थ दे इस वजह तो मेरा रेंट भी है
Come on, you got to tell me now, please. Tell me.
She said that she can't afford it because she is working on minimum wage and because she has a lot of medical expenses and therapy expenses because of her shoulder rotated cuff is broken and she needs surgery for that. So she's been going to therapy and to the hospitals and appointments and she has a lot of medical expenses.
Mr. Saloom, tell me what you're asking for. And I want you to go slow so this young lady can interpret.
Yes, Your Honor. So pursuant to the garnishments, we were receiving, I think, approximately $630 a month. But we would agree to accept $300 a month. We've tried to work out a payment plan with her, but haven't been able to do that.
She's only making $2,400 a month. She's got a motion here that says she pays $1,800 in rent and $600 in utilities.
I see. Yeah, Your Honor, I guess a more reasonable request would be $150 a month.
Well, I'm going to make it $40 a month. Sorry. I'm going to ask you to tell your mother, ma'am, tell her I'm gonna order that you pay $40 per month,
the payable to 40 per month. The amount
and I'm gonna ask you to prepare an order to that effect, Mr.
There
Sloan,
may,
if you would, please.
yeah, we will. There may be one in the file. I don't know. Well, maybe not, But in any case,
$40 per month, beginning January 10th, and the 10th of every month thereafter until paid in full.
There's something my mom wants to tell, and it's that she recently filed for a medical leave at her work where it wasn't covered, and she works part-time now, and it's hard for her to manage the expenses, so she wants to know if you can please go down. And she barely goes like 2 days a week now.
Jeez, I can't do much better. I'll make it 25 per month, and I'll start it beginning February the 10th. And the 10th
Your
of
Honor,
every month.
if I may, this is approximately a $10,000 judgment.
I know.
And I appreciate her predicament, but whether it's 25 or 40, that's just, that's something people kind of work with, whether they're up or down as far as meeting their obligations. And, I think the court knows my position.
I get it, but that's my order. $25 a month starting February 10th. 25 a month starting February 10th. Now tell your mother they still can garnish. They still can garnish. This, listen. They can still garnish they can't garnish wages, but they can garnish tax returns, bank accounts, and the like. So she needs to understand that. They still could garnish her tax returns. That's the best I can do. Tell her. Would you please tell her everything I'm saying?
Bank account ਦੇ ਵਿੱਚੋਂ ਤੇ taxes ਲੈ ਸਕਦੇ ਨੇ ਤੇ ਇਹ ਸਭ ਤੋਂ best ਹੋ ਕਰ ਸਕਦਾ ਹੈ.
Can't do better than that. I'm sorry.
She wants to know if she can send the installments on her own.
Yeah, tell her where to send them, Mr. Saloon.
Yes, that's fine. We're going to send an order to the court for installment payments of $25 a month beginning February 10th, 2025. And we'll have a PO box and an address where she can mail the payments to us.
Tell her that. Tell her that.
On the bay o tenu address send kareda jithe tu ਉਹਨਾਂ ਨੂੰ send ਕਰ ਸਕਨੀ ਹੈ.
That's it. Thank you both. Have a good day.
Thank you, Your Honor. Have a good day.
Thank you. Happy holidays, Mr.
Oh, Your Honor, one last thing. Is there, I don't know if there's a pending garnishment, or I know it was filed in October. It's some.
Is there a garnishment already filed in this?
Judge, I'm pulling up the garnishments right now.
If there is, I would just ask that anything being withheld be released to plaintiff's counsel.
Yes, there was one issued in September.
If anything's been withheld, tell her that on the garnishment, it's going to be sent to the plaintiff lawyer. On the garnishment.
ਜੇ garnishment ਦੇ ਵਿੱਚੋਂ ਕੁਝ withheld ਹੋਇਆ ਵੇ ਤੇ ਉਹ plaintiff lawyer ਨੂੰ ਮਿਲਣਾ ਵੇ. What does that mean?
It means if her wages have been garnished, then her employer's been keeping the money, and they are going to send that to Mr. Saloon and the plaintiff's lawyer. Okay?
So she's not gonna get them?
No.
Okay.
No. Okay?
Your Honor, do you need us to do an order on the
all of that? All of that. The sooner the better. Okay. Thank you.
Both. Thank
you.
Have a good day.
She wants to know if she can get the garnishments back.
No. Okay, I've been too fair. I haven't been fair with them, if anything. Have a good holiday, everybody. What's your name?
You as well, Judge. Thank you. Everyone have a good
What's
day.
that? Ronald St. Louis versus Brian Marshall, 2502190R. Everybody, state their name.
Before Gerard Scanlon, P number 74992, appearing on behalf of the witness Brian Marshall, the president to my right.
Your name, sir?
Morning, Your Honor, Brian Marshall.
Mr. St. Louis, your name?
Donald St. Louis.
All right, let me just look back and file momentarily here. All right. You know what? I hate this M filing. I just don't get it. I'm all for change if it makes it better, but it hasn't made it better. It's made it 4 times more complicated. So I don't have a small claims. This was initially filed in small claims, right?
That's correct, Your Honor.
Jennifer, have somebody bring me down the small claims affidavit. Before
pulling it
then,
up
I
right
had,
now.
before then I had files. It was a lot easier, but
Your Honor, if I may.
yeah, you can handle that.
Thank you.
All right, so I've got Mr. St. Louis claiming for labor performed. You're claiming 2789, right? Mr. St. Louis,
He returned my tools after.
how much are you claiming?
Just the 2,000 plus the court fine.
$2,000. What's the $2,000 for?
Wages for all the work performed,
Okay,
up to the point of where we had to move to another job because 2 weeks turned into 4 weeks and it wasn't going anywhere because he wasn't.
all right, okay. Sit down, everybody. Give me your opening statement, Mr. St. Louis. You can tell me what your theory of the case is.
We were working on a job on Philly and Allen Park, Carlos, my partner and myself. For him. He wrote it up and doing the job. He approached us about his girlfriend, homeowner / Lauren. Wanted to have a bathroom redone. So, for the record, he's my stepson, you know. So I went when I met him at Lauren's house. And she went through the whole procedure of what she wants to do, that she do this, how she'd like to have it done. And I'm like, okay, so when it was all said and done, she went around in another part of the home to water plants, and he said, well, how much are you guys gonna charge? I said to do all that work, except he was gonna do all the tile work in the bathroom. She's fine. I said 4,800. We had a week to go still, and then when she went on vacation, because it was a 2-week vacation she was taking. I started. The first night, the first time in there, he was in there and started helping him. And I asked him, I said, what are you doing? Are you taking away work from Carlos and I that you wanted us to do? And he goes, well, I'm just helping you get going. Don't worry, you're gonna get all the money. So I continued to go. Carlos would come when he was doing the skin work, the finishing muddy over on another job. So he'd go there for a couple hours, then come over and we'd work together. We completed demo of ripping out all the walls and everything.
All right, I just want to hear what your theory of the case is. He owes you money.
Right.
He owes you $2,000.
I'm being generous on that, Your Honor, because I'm gonna go on. Just being fair about it. For the amount of time and work I had to put in with him, including using my truck 2 times to go to Home Depot, meet him, load it up with cement, go back to her place, mix it, and all that. He just, for some reason, couldn't stay out of getting it so involved in this, and there was the problem. He was supposed to supply all the materials, we could have been in and out. But it didn't happen, so we put up with it to the point where the other job, Mr. Phillips in Dearborn Heights, had already, we backed him up 1 week, going into totally doing his whole remodeling on kitchen and everything. And finally we had to go 4 weeks. He wanted 2. Can we get it done in 2? I said, yes. But at no point were we supposed to deal with him being involved with, he works for major contractor. He ain't even around during the day. And then twice on weekends, he was gone. Once he took his daughter up north to visit the grandpa. Okay, that's fine. But we could not get the material to complete this job. So I figured.
It's your paperwork. That's wise to be.
Good. I figured we normally figure out jobs out at $30 an hour labor. I got at least 80 hours, actually probably more, but I settled for 80. Carlos got 12 coming there. And that there would have been 24 on me and another 340 on him, something like that. So I just went down to 2. That was it.
All right, okay.
The only, but we don't track hours. We bid a job according to what the job is worth on the market. So that's why I said 4,800, but if I had to be reasonable, because they brought it up wanting to know how many hours. Well, we don't track hours, but if I had to give a rough guess, that's where I would put it. To, you know, about 20 some, just over 20, or pardon me, Your Honor. 80, well, closer to 90 hours, 90. But I'll settle it. I mean, simple math.
So you're charging $100 an hour, basically?
No. $30 an hour times 80 hours. That's 2,400.
Okay.
And 12 hours for Carlos when he was there helping me with all, as I submitted into your file, as you instructed to make sure I complete the thing for the court. There's pictures there, but that's not pictures of all the work that was done. I took pictures of a lot.
All right, okay, let me hear from you.
Main premise of this cause of action, Your Honor, is that my client didn't supply the materials for the job.
Did.
That's the main premise. Didn't supply the materials. That's what he said. When asked in an interrogatory to describe how the breach occurred, his answer was Brian failed to supply the materials for the job. And I've got receipts that show clearly that my client has spent over $2,000 in materials and he's prepared to testify with it. Further, I've also cited a case in my trial brief. This is the Van Dyke's case that indicates that when a job is done for a family member, which Mr. St. Louis has already testified that my client is the stepson, it's done for and gratuitously done and or furnished. In that there's a presumption that arises that Mr. St. Louis is going to have to overcome according to the case law. He has no cause of action. He has no damages. My client supplied the materials, and thus we're asking that the case be dismissed and costs and attorney fees be awarded.
We did some work, though. Nobody's disputing you did work, are they?
That's not the nature of the breach. The nature of the breach is, according to him, in his own words, in the interrogatories that I'm going to introduce as evidence, the nature of the breach is that he failed to supply the materials. My client has receipts from Home Depot indicating that the materials were purchased and he's prepared to testify that he did purchase them.
All right.
Therefore, he has no cause of action.
Call your first witness. Call your first witness. If you want to testify, you can come up here. If you don't, you can call your friend here, or you can call the defendant here, or call whoever you want. But you got to come up and I'm going to swear you to an oath. That was just an opening statement before. Yep. Raise your right hand. You solemnly swear to affirm under penalties of perjury that the testimony you give in these proceedings will be the whole truth self you got. Have a seat. All right, go ahead and tell me. Now you can be detailed. Go ahead. Tell me everything you want to tell me.
When I went in there, they had already been doing shopping. Toilet somewhere, it was worth $1,000.
Are you charging for the labor or for the materials?
Just the labor. The agreement was he's gonna supply the material when I needed it, not purchasing a cabinet here, a toilet that was all done before we even started. I mean, going in, they had stuff stockpiling, so if this material for receipts is where he's going, the only materials he bought while I was there working was copper, piping, fittings, shut-offs, the PVC 3-inch, 2-inch, and 1.5 inches for the drain systems. There was some lumber.
Sir, I'm asking you, are you suing for labor or materials or a combination thereof?
Just labor, sir, Your Honor.
Just labor.
Here, that's all, Your Honor.
All right. And how many hours labor did you have?
I'm saying I can safely say I put it at minimum 20 hours labor. We charge $30 an hour labor. That's a very good rate in this kind of.
Okay, that's $600. How are you coming up with 2,000?
80 hours.
You said 20 hours.
Oh, I'm sorry. I'm wrong. 80 hours, 2 weeks. I was there for over a 4-week stretch, in the evening and on weekends.
And what did you do in that 80 hours? I'm sorry?
Finished demoing all the old walls and everything. Then I had to remove piping. And there was 2 exterior walls when we come in. I ended up removing them. Copper, Then I was doing rerouting copper for where it was supposed to go, the whole drain system. He cut the floor out because he was.
I want to know what you did. Don't talk about him.
Yeah.
What else?
Then I was there in the evenings helping him. Like I said.
What were you doing?
People got cement, come back, mixing cement. He took it in and doing that.
What else?
The wire, moved couldn't move all of it. Some
Demoed the walls, removed the piping,
repaired and.
rerouted the carpet, and you went over and got cement for him. That take 80 hours to do all that?
Oh, yes.
80 hours to do all that?
Yes, you're.
Okay, what else? Anything else?
Because there,
I just want to know what else you did.
there's a lot. I should.
I want to know. Tell me.
So the walls that I removed were the existing old walls. Okay, and then I chipped around to give him an idea of where the plumbing had to run. I had to retake apart. This is it. He was going to do stuff in the evening. And then the next day I got to clean up when
I want to know what you did. Just tell me what you did. I don't want to know what he did. I want to know what you did.
And I loaded the trailer and hauled it to the dump, emptied it and brought it back, which I even paid the dumping fee. Which that was out of my own pocket. So all this work that I put in time putting in on this job. And many other times it was cleanup after him leaving a mess all over. That was it.
And he tell you he was going to pay you $30 an hour.
No, he agreed to pay 48 for the job, but we were
48 what?
$4,800 for the whole job. Then.
But you never got that in writing.
No, we had a verbal agreement and when he even discussed it with, talked to Carl about working over there too.
All right, go ahead.
So basically, we're just asking for the amount of work we did came to almost half of the work that was supposed to be put in, not counting Kyle.
All right.
That was his understanding and agreement.
Okay, fair enough. You got questions for him, Mr. Scanlon?
You. St. Louis, you indicated that you don't have anything to prove that this conversation between you and my client took place, correct? Regarding
Regarding house or at the Fillmore?
you don't have any proof regarding the conversation that took place that indicated that my client was going to pay you $4,800 for this job. Nothing in writing.
Nothing in writing, no.
Okay, and you indicated that you don't have anything in writing to prove that my client offered to pay you $30 an hour for labor performed on this job.
No, he wanted the ballpark price for the job, which I quoted 4,800.
Your Honor, can I approach the witness?
Yes. Did you work with your stepson on work before?
Yes, we were coming off, back there, we were coming off of a house in Allen Park, Philomene. We opened up the kitchen, removed walls, redone it. I moved, electrical, plumbing. Actually, I did a lot of electrical for it. We had no written agreement. It was a verbal agreement on that one too, which.
All right, okay. I just asked you if you'd worked with him before. That's good. You answered the question. You can proceed.
I'm gonna approach the witness, Your Honor, show him what's been marked as proposed exhibit, defense proposed exhibit. Hey, sorry. Sir, do you recognize that document?
Did you just mark that yourself?
I did, unless you're a sticker.
Yeah, we're gonna mark it defense one. Hand that back to my recorder, will you, Mr. Scanlon, please?
Defense one?
Yes.
Recognize that document, sir? Whole thing? Yeah, I'll give you some time to look through it.
I'm reading, it was more about supplying material. He kept.
I didn't hear a word you said, sir.
I'm sorry, there's no question. I just asked if you recognize the document, sir, yes or no?
Yes, I do.
Okay, how do you recognize that document?
Well, you sent it to me.
Okay, and these are interrogatories that were sent to you by my firm. I'd like to draw your attention. Question number 5. You could turn to that one, please.
Yeah, I got it right there.
Says, please describe in detail how the verbal agreement between you and the defendant was breached. Can you read for me your answer, please?
Brian failed to supply all material for us and continued to disrupt the work that Carlos and myself agreed to do from the agreement we made.
Okay. So that answer indicates that my client, the breach of the contract occurred because my client failed to supply the material, is it not?
Well, there was more than just that.
So yes or no question, sir? That was
Part of it.
Well,
Yes or
yeah,
no?
that was the answer you gave though, right?
Yes.
Okay.
Well, there you have it.
I know. What else, Mr. Scanlon? I think this is pretty easy. I want to hear from your client.
Understood, Your Honor. I just want to put the proofs on the.
All right, go ahead. Ask me your next question.
Question number 5. I'm going to ask you to produce a copy of any invoices you sent to my client for any outstanding balances. You didn't send him any outstanding invoices, did you, sir?
No, I wasn't buying anything.
All right. But you never sent him any outstanding balances for any materials, and you never sent him any outstanding balances for the labor work, right? Yes or no?
There is no balance for material. I was not responsible for purchasing it. So why would I send it?
It's not a question.
I don't need you to argue with him, but I got his answer. Move on to your next question.
And you indicated, sir, that Mr. Marshall is your stepson?
That's correct.
I have nothing further for this witness at this time, Your Honor.
You have any other testimony you want to offer? Yes or no? No. Okay, I want to hear from Mr. Marshall. Come on up here, Mr. Marshall.
Sorry, I moved to admit this.
Yeah, you can move to admit that. That's defense one, right?
That's defense was even one.
Any objection to the admission of that, Mr. No, Your Honor. Defense one is admitted. Mr. Marshall, come on up here. Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat.
Your Honor.
Wait.
I do believe that what he just admitted, I already gave you a copy in the file.
It's fine. It's fine. Did you hire him to do some work for you?
I did request, or if they'd be willing.
I can't hear you. Keep your voice up. Did you hire your stepfather to do work for you?
I requested assistance for him.
Did you pay him?
I did not pay him. He was under he was gonna help me with my girlfriend's bathroom.
Did you pay him on the prior job that he had just described that he helped you with?
I did, Your Honor. That was through my construction company.
But you didn't pay him on this one?
Correct.
Did you ever stop him from going over there?
I would never stop him from going over.
Did you ever tell him, I'm not paying you for this?
I mentioned it on a text message when he called and said I owe him money for work he performed. I told him that I was gonna, it was the, if I may, Your Honor, the bathroom was for my girlfriend. It was boyfriend helping girlfriend.
No, it wasn't. It was your girlfriend, not his.
Right, not his girlfriend.
Right? Wait, wait. I want to ask you some questions here, and I get it. Do you have any reason to dispute that he worked on that bathroom?
No.
You heard how many hours he said he worked. He said he worked 80 hours. Do you have any reason to dispute that?
That number.
How many hours do you think he spent working over there?
Realistic work is probably 10.
10 hours?
10, if you, I would give him 20.
Did he demo the walls?
I assisted in demoing, yeah.
I didn't ask you that.
Yes.
Did he demo the walls? Did he remove the pipe?
Yes.
Did he reroute the copper?
No,
Did he go and get supplies from time to time?
he assisted me, but
He got cement, right?
in his truck with my.
And he brought it back there, right?
Correct.
And was your girlfriend home the whole time?
No,
Were you there every time that he was working there? How did he gain access if you weren't there and the girlfriend wasn't there?
We had a key provided by McNally's.
Is $30 an hour a normal price for that work?
Yeah, that's a fair price.
But you expected him to give it to you, do this work for free?
Was a team effort. Carlos was gonna be the gentleman who came in and did.
I know, but he wasn't the girlfriend, right? I mean, you were doing this for your girlfriend, right?
Correct.
Was he friends with your girlfriend?
Yes,
Was he friends with your girlfriend before he started working on the job?
yes. He's known her for a long time.
How long's a long time?
Maybe my girlfriend and I have been together for 8 years.
How sad. You guys are father-in-laws. I mean, stepfather and stepson, and you guys are in here and, huh?
I agree.
Well, I know, but I don't think you've been fair with him. You want my honest opinion? I don't think you've been fair with him. You better make it 100% certain, 100% clear that you're not paying him. If you're going to have him do work, I don't care if it's on your girlfriend's, I don't care whose house it is, your friends, I don't care. Do you have any questions of him?
Mr. Marshall, you indicated that the amount of work that was done by Mr. Singh was amounted to maybe 20 hours. Correct. Not the 80 that he's indicated. Correct. And you did in fact pay for labor or materials rather, from Home Depot. That's right. Okay. And you had those on your credit card statements? Correct, the Home Depot credit card statements. No, very close to witness.
Yeah, sure. I don't care what he answered on the interrogatories. But did he say or not say that he wasn't speaking any amounts for materials?
It's the basis of his lawsuit.
Well, I don't think so. It sounds to me like it's more labor. Are you not suing for the labor?
Labor only, Your Honor, time put in. For work done.
Even his affidavit, money's owing for labor performed at 23776 Carter Road, Brownstown.
Right.
I don't care what he said in an interrogatory. He's not a lawyer. He did a half-hazard job. I'm not even considering materials here. I'm not awarding him anything for materials. So I don't think we got to talk about materials because it's not relevant. Unless we get into the 4,800 and you want to start talking about that. 4,800 included materials, and so this guy, Mr. Marshall, bought some of the materials, so that should rightfully come off the contract price. But I'm just telling you how I'm leaning here, and that is this guy's entitled to quantum merit. Whether they had a ironclad solid agreement or not, $30 in the industry is not outrageous. He clearly did some work. The question is how much work, and it has nothing to do with the materials. But go ahead, you ask, and I'll rule, and I'll stop you if I think you're going off into places that are.
Well, and I would argue, Your Honor, too, that he answered these interrogatories and indicated that the breach occurred because materials weren't paid for. Regardless of
The
whether.
first word of his claim is for labor performed.
Right.
Look at his affidavit and claim.
So what's the basis?
Hang on, I want you to look at his affidavit.
I did. What's his basis?
He said money's owing for labor performed. Why are you arguing with? I mean, that you got it. I could read this when I was 6. Money's owing for labor performed. He doesn't say anything about repairs. I'm sorry, it doesn't say anything about materials.
So he's indicating that there's labor, yet when he answers the interrogatory.
I know, I get it. That can go to his credibility. I get it, but that's what his claim's for. And I heard everything you said, that he indicated that this gentleman didn't supply him with the materials. I get it. But I don't think he's really talked about materials. He talked about picking up materials maybe that Mr. Marshall should have picked up. Go ahead, ask your next question.
No, that's fine. I'll rest.
No, I don't, listen, I'm not trying to talk. This is a very small case. And I want to afford you every opportunity to ask whatever you want. I'm just telling you where I'm going with that. And that's what I'm gonna do on these little cases. That's what I always do. And so we don't have to guess. This isn't over 25,000 or anything more, but go ahead. Let's. All right. Do you have any questions of him?
I do, Your Honor.
Go ahead.
Finished on that Sunday. And you stormed out because you wanted to run wiring and I'm like, upset of you. Now, after that day, I called you. I said, I need the rest of my tools.
Is this a question or a testimony?
I wanted to verify that this is what I asked you for money owing. What was your response to that?
You asked if I had your planner.
No, about the money. When I said you owe me $2,000, what was your response?
I don't know you when you locked up the job.
You said you don't have to pay me because we didn't have a written contract. Is that correct?
I don't know. Exactly. I gave her a text message, so.
When I told you that night how much money that Carlos and I would expect to do everything, and you were only gonna handle tile work at the end. Did you inform Lauren about that?
Lauren was present during the conversation.
She was not present when I told you the amount of money. There was only you and I.
All right, you can't argue with him.
Yeah.
You can come back up on rebuttal and tell me something different, but you can't argue with him. He's not giving you the answer you want.
Did the homeowner know that the amount of money we wanted?
Lauren was present there.
Chad calls for speculation.
That's fair. I'm gonna sustain. Strike that answer. Go ahead and ask your next question.
That's it, Your Honor.
You can step down, sir, unless you have something else. Come on back. I want to hear from you. Is this your buddy here?
This is Carlos Velazquez. Him and I have been teamed up for 27 years working together.
Come on up here. Can you spell your name for my recorder?
V as in Victor, ELASQUEZ.
Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat. You know which residents they're talking about.
What's that?
You know which residents they're talking about.
48 minutes. That's the city that Brian's girlfriend lives in.
Did you do work there?
Yes.
How much work did you do?
Help Brown doing the plumbing.
I didn't ask you that. How much work? How many hours? What did you do?
I assisted Brian with plumbing and doing a couple framings and walls. Right by the backside of the shower. I was at another job, in between jobs, and while I was letting stuff dry over there, I would come and help Ron a little bit. That's how we work. So he would do the plumbing, electrical to get started, then I would come over there, then we would do the drywall. I would finish all the drywall, then we will assemble everything, because it's a step-by-step process, doing things like that.
Do you have any questions of him?
No, Your Honor.
Do you have any questions on him?
Well, how much time did you spend on this job?
About 14 hours.
That's it?
Yes. We was in the middle of another job. I was finishing the other job.
Were you
In the
there?
process, I would go over and help him with a few things.
Were you there the entire time that Mr. St. Louis was there?
I was not.
So you have no way of saying how many hours Mr. St. Louis spent on this job?
The way the job works, it's not,
Yes,
it's
sir.
like a small puzzle.
Right.
So, no, I wasn't there the full time.
So you don't have any idea how many hours Mr. St. Louis?
Just basically from what he told me every single day call.
Okay, thank you.
I'm sorry, I didn't hear that.
Basically, every day he would call me. And he would tell me, what he did. It just,
Any other questions of him? Either one of you?
All right.
You can step down, sir. Thank you.
Thank you.
Do you have any other witnesses, Mr. St. Louis?
No, Your Honor.
Do you have any witnesses, Mr. Scanlon?
No, Your Honor.
Any argument, Mr. St. Louis?
I don't know if your honor has had a chance to look at all the pictures that I put in the file for the court when I filed it here, the response from his attorney.
I don't look at photographs and documents like that unless they're admitted into evidence. Is there something you wanted to admit into evidence? That you wanted me to look at?
Enter all these as evidence.
What are those?
Pictures of work that was performed.
How many pictures you have? How many? More than 5?
Oh, yes, more than 20.
I mean, I can have them marked if you want. Mr. Scanlon, any objection to me just marking all of those pictures as plaintiffs in one? You gotta lay a foundation. I mean,
There's no foundation for them and they weren't produced prior to, the court had a scheduling order on this case. He was supposed to produce those prior to, he didn't. So I would completely object to that. It's inappropriate.
Your honor, that form that he showed you with all the questions that I answered, I also turned in an envelope inside that vanilla that had pictures exactly of what you have here. Was turned in at his.
all right, okay. Give me the pictures. Hand up the pictures. How many pictures you got? 20? Why don't I,
Oh, do I give it to you, sir?
you tell me how many pictures you have there. Let me see. Mr. Scanlon, I could let him come back up here. I mean, what's fair is fair.
I'm sorry. Who you're on?
I'm gonna just have these marked 1. You saw all these pictures, right?
No, I have not.
You've not seen these?
No.
It's roughly 20 pictures here. I'll let you take a look at these. And my inclination is to have the first picture marked plaintiffs 1. Mark outside on an envelope plaintiffs 1 and put all these pictures in here. Take a look at those. You're still under oath a second here. Do these pictures demonstrate all the work you performed at this residence?
No, they do not. There is some in there where early pictures of where I was rerouting copper, and then I should have taken pictures at the last day of finished the copper run.
But all the pictures there, do they reflect work that you yourself did personally?
They do, Your Honor, except the removal of the concrete.
Do you want to have me mark those?
No, not at all. I don't even know. He just established a foundation for that.
Man, okay, hand them back. I'm not gonna admit those. I'm gonna listen to you both argue. Tell me, what would you like to say?
Pardon me, Your Honor.
I'm gonna have you guys argue your closing arguments. Nobody else has any witnesses, right, Mr. Scanlon? Mr. Scanlon, you don't have any other witnesses, right?
No, I don't.
Go ahead.
I have no other witnesses either, Your Honor.
I know, I want to hear what argument. You want to make an argument? You don't have to.
No, other than the fact that the work was performed, his evaluation, I can understand why he wants to lowball hours, but just on the cement work for 2 times this, 10 hours of my time there.
Okay.
What
do you have to say, Mr. Scanlon?
Burden of proof is on the plaintiff, Your Honor, to prove his case. He has the burden to produce evidence to show the court, proof to show the court how many hours he's actually worked. We have no testimony from any witness that would reflect that he actually performed 80 hours of work on this property. His own friend Carlos didn't even testify that he was there with him at the time that the job was being performed, so he couldn't even verify how many hours were actually performed on this particular property. This was an unfortunate job where you have 2 individuals, a stepson and a stepfather, that are fighting over a verbal agreement. No evidence of the agreement, no evidence of anything in writing, no evidence that my client indicated that he was going to pay him. I asked that this case be dismissed.
Thank you. Anything else, Mr. St. Louis?
Yes, Your Honor, if there was no agreement, why would he, tell me on the phone when I had a request payment, he didn't have to pay me because we didn't.
I don't want to hear anymore.
No.
I don't want to hear anymore.
Yeah.
If you were not going to pay him, it was incumbent upon you, Mr. Marshall, to fully and completely let him know that. Especially if you'd come off another job. This wasn't like you went to him. I heard no testimony. You went to him and said, hey, listen, you know, Susie or whatever her name is, we've been going out 8 years. We're all close. I'd appreciate it if you do me a break on this, give me a break on this and help her out and not charge her or not charge her through me or make me eat the price of this because you're helping me. And I've got to pay you. I heard nothing like that. And I got to tell you, whether I admitted those pictures or not, based on what he told me, and I'm no construction guy, sounds like a lot of work. I have no reason to disbelieve his testimony. Judgment for plaintiff, 2,000 plus the 88 filing fee. And if you have any other fees, you have a motion fee, I believe $20, maybe not. What other judgment or fees does he have here, Jen? You have any other out of court?
Judge, I think that's it.
I think that might be defendant's motion filing fee.
It was
you got-
defendant's motion.
Yes, so I'm gonna make it 2,088. Can you pay this today, sir? When can you pay this? Okay. If there's a way you can go get it today and write him a check, I can do a stipulated dismissal. If you can't, I have to do a judgment.
I can get a check.
Today,
I can make it out.
can you get it here in the next half an hour? Yeah, you good with coming back in an hour?
I am here on.
The quicker the better. Mr. Scanlon, will you prepare a stipulated order for dismissal with prejudice? And then I'm gonna wait here. I'm not gonna go anywhere. And my staff's not gonna be able to go anywhere. So I'm gonna ask you to go hustle on this. And we'll go from there, okay? And then we'll do a stipulated order to dismiss with prejudice once he tenders the check. Okay, thank you. All right, what do I have with you, Mr. Collis?
That's
Your
Ms.
Honor, you
Davis's
have that
case.
motion to reinstate that last week, Ms. Davis couldn't hear us, even though we were talking and she was.
Herself
supposed to come
versus
in.
Wanda Davis, 2404457.
Good morning, Your Honor. For the record, Stuart Collis on behalf of the plaintiff in this matter.
All right, ma'am, your name? So this gentleman was here, you were here and you couldn't hear us last week, so we adjourned it. He asked me to reinstate the case. It got dismissed for no progress, right, Mr. Collis?
That's my understanding, Your Honor.
All right, so what I'm gonna do is, Jennifer, is that what happened here?
I'm looking, yes, dismissed for lack of progress, Your Honor.
So I'm gonna reinstate the case. Motion to reinstate is granted. And then I'm gonna give you, ma'am, I'm gonna give you 21 days to answer the complaint. So motion reinstate case granted, defendant to be served with copy of order reinstating case, and copy of summons and complaint to be sent to her last known address. Where do you live now, ma'am?
18758 Van Horn Road,
187 what?
58
58?
Van 2, 1 Michigan, 412.
Where is that? Bristol Hills or what? Okay. So you prepare the order, you send it to her, she'll have 21 days to answer.
Yes,
And
Your
then-
Honor. I'll
and if-
prepare that order and e-file that
Ma'am,
immediately.
if you don't have a defense to the case, I would just suggest that you just get with Mr. Collis, he's a reasonable man, and set up a payment plan.
That's what I wanna do.
So maybe you can call them in the next day or so. And then try to resolve it.
Sounds like a plan.
Okay, so send me that order and you guys talk and see if you can resolve it, okay?
Absolutely, Your Honor.
Thank you
Have
very
great
much.
holidays.
You too. Happy holidays to you, Mr. Collis. Thank you.
Thank you very much. Hope you have a great New Year too.
Thank you. You too. Do I have Vikky Assenmacher here on this one, Jennifer?
Judge, that was the last one I had was for Davis.
I don't know why Vikky Assenmacher. Maybe this is the one where I denied the motion.
You know what? I think we got some sort of documents in on that. So if you had your copies, that might.
We're done. Thank you. Thank you.